members, actually 3 new staff members. Jen Klinger, she came in March. Kim Britton, she came in April. And then Tim Black was assigned to us the first part of July. So we're going through some personnel changes, and I think once we get down into the numbers, you'll see that the personnel changes were really good. I listed the statistics for the first half of last year and the first half of this year. And as you can see, we didn't celebrate it too much. I did a little jig and dance in March and May when we actually got into the 40,000s. And then last month we had our first $50,000 month. We have an increase of $87,347.95, which is a 54% increase from where we were last year at this time.
So did you dance on the next slide?
Yes.
It's also on YouTube. Thanks, girls.
To the Dropkick Murphys.
Do you have any questions as far as the collections?
So, Mike, what do you attribute your success? To what do you attribute your success?
I think it would have to be the team that we built. Melissa put her confidence in me when she hired me last October as the supervisor of the unit. Again, we did have some transition with some personnel leaving. In the past, there was some conflict between those people, but they're not here now, and Melissa and I interviewed 3 folks over here, and I think we have built a very good team. It's not her job, his job, it's our job as a team, and we work as a team.
I think that's one of the differences. While the unit was being successful before, it was very much a division of labor. And I think they're getting away from that. I think they're all working towards
Division's great word. I saw your face.
but they're all working very well together, and it's very much more a team effort than it ever has been in the past.
Okay, moving on to the 2,000 criminal restitution collected year to date. This is the number that I pulled off CPCMS, and this is only for criminal cases, and for whatever reason I can't divide it as far as what department, so I'm just giving you a general number for countywide for the criminal cases. A little over $500,000 has been collected in restitution, and that's countywide. That's my department, probation, through the DJs. I think Mike will comment a little bit later, and I'll make note from his reports, the restitution to insurance companies are up 98%, and then the restitution to individuals and non-insurance companies. Mike has for the report for June of 2017, 5%, but I'd just like to make note that the report that he gave us at the end of May, we were actually down 6%. So within a month, we have gained that 6% plus another 5%. So we're up 11% for restitutions to individuals and non-insurance companies.
And as far as the money that goes to insurance companies, you don't have control over, you bring in the money, how it's dispensed is up to clerk of courts.
Correct.
It is not actually up to the clerk of courts. It is actually statutory, and our judges have designated restitution 100% until paid in full. And the system is set up to pay victim people first, I believe, and then insurance companies. But it depends who paid. If you've got someone who sends in a $10,000 payment, but they owe an insurance company, that's going to make these numbers jump. So it may just be that the people who owe insurance companies have jobs and wage attached in a much more consistent manner. For some reason, I'm curious where those numbers came from, so it's something I'm going to look into after. I mean, why is it not an 80% increase?
I think you think we're doing all this to benefit.
No, but we don't have a lot of choice in that much. It is statutory, and we do have it set up though that 100% goes to victim restitution prior to going to any costs, fines, or insurance restitution.
moving on, the exonerations that our unit has done for 2017. You go to the bottom of the first page and the bottom of the second page. Larry, do you have the clicker?
I got it. The top of the second page.
Top of the second page, we've exonerated $333,919.49 of essentially bad, non-collectible debt to the county. All of these exonerations, if you look in the parentheses, are the first number are the number of dockets, I'm sorry, the number of defendants, and then the second number are the number of dockets associated with those defendants. All but one out of the 64 are deceased. And the other one we exonerated fines and costs. Once that first, there was an agreement made earlier before me that once all the restitution was paid, that person will be exonerated from their fines and costs. So 63 of those cases are exonerated because of that.
So except for one,
Yes, sir.
they're all deceased?
Yes, sir. The next item, the update on the collection agencies. Again, we are all relatively new. We're still getting our feet wet with the collection agencies, referring to the collections agencies and also recalling them back. As of the end of June, we have 349 cases referred for $384,686.54. CMC collections year to date is only $108.75. MSB collections is $4,723.40. I'm finding that MSB is the stronger of the collection agencies. That $4,700 is only out of 2 cases. So I think they're doing a lot better job for us. I spoke with CMC this week on the telephone. Apparently they have some issues with us not receiving the funds that they have collected. So I have someone working on that to see what money is still owed to Cumberland County. And they're going to clarify that with the clerk of courts.
So, that money there has been more than $108 collected by
$100
CMC, but that has not been credited to people's accounts?
Apparently, yes. I don't have an exact number. I have someone working on it with CMC, and they're looking into it. So that's all the information I have right now on that.
That's pretty serious.
Yeah.
Because this is what you're supposed to do, this is what you're supposed to be expert at. Seamless, flawless.
And it's not automatic. I brought a case to Melissa's attention yesterday that MSB collected, it's a little bit off subject, but for someone who has a felony extradition warrant out of Cumberland County, the person has paid their fines in full. So I will work with that case whenever we actually get the payment, but I don't expect that payment to get to us in the form of a check probably until mid-August. I don't know what their schedule is as far as cutting checks and getting them to us, but once that check comes in and that account is cleared, then we'll work with whatever we need to do to get that person extradited.
And how are CMC and MSB compensated?
By commission. They don't charge the county anything, but they charge their commission, and that's how they're paid.
Okay. So if we look at the MSB number 4,723, does that include their commission, or is that excluding their commission, and how much of the commission did they receive?
That's just what the county got.
So how much of a commission did they receive?
Each of them, I believe, get 25%.
Does that come out of, does the defendant pay that?
Yep.
And it does not come off of the total due.
So it's total due plus commission is what the person pays.
So for 2 cases, the collection agency got paid what?
A little over $1,000.
A little over $1,000.
We have referred 349 cases to them.
Yes, sir.
Does that mean they're no longer on our radar?
Those agencies are working those cases.
Okay.
So, yes, they're not on our radar. But I can go in to CPCMS, look at cases that are over 180 days that are non-collectible, have not had any collections on, and then I can recall them and either send them to another collection agency, or I would prefer, I have a note here, I would prefer to work the case a little bit, try to update the address, maybe either do a warrant on them or a license suspension, and or refer back to another collection agency.
Mike, the cases that you refer to, each collection agencies, approximately how long have they had them to work on? If that's an easy question.
The MSB one is pretty simple. We did a big referral to them on May 5th.
Okay.
That was our first experience with MSB because we were recalling cases that Lori Rado submitted last November. So from November to the end of April, it would have been 180 days with no collections. So we recalled them and sent them directly over to MSB.
So basically leaving them for 180 days with each agency, and then recalling and trying the other agency, but
Okay.
recalling and working, they're working on themselves.
Okay, moving on to the driver's license update. Should find this entertaining. We submitted our first test group on May 5th, and we submitted 7 defendants for 10 docket numbers. And there is a typo under the 86% response rate. 5 defendants paid in full, and only 1 defendant had set up a new payment plan, and I had 2 did. So we had an 86% response rate out of the first 7 defendants, which I thought was really good. And then we started to continue with the driver's license suspensions. Year to date, we've suspended 96, and we've had 20 people respond, 8 people pay in full, and 12 on payment plans. What I'm trying to do, it's very time consuming to identify, first of all, who has a valid driver's license. Once I do that, I also try to update the address through CPCMS and TLO. If they do have a valid driver's license, then I go ahead with the suspension if no payment has been made within the last 180 days. I'm finding that I'm having more luck with people who are from out of state because we will not extradite somebody for fines and costs in another state, but they will suspend their driver's license. So through the interstate compact, 48 out of the 50 states are in the compact that they will do reciprocal suspensions from this state to that state. So we've been having a lot of luck with out-of-staters. A lot of them you'll find are truckers who either have, weight issues or a ticket on the turnpike or something. They have a CDL. They don't want to lose their license, so they contact us immediately. So the driver's license suspensions, the previous people that were here, we talked about it. You wanted it up and running, so now it's up and running. The only thing that we can do is go forward and identify what cases we can suspend and suspend more cases. I spoke at the last collection advisory meeting that instead of us spending our resources contacting the people, we're just going to go ahead and suspend their license and let PennDOT incur the cost of manpower and postage to notify these people.
And the bench was okay with that, which they'd previously been opposed, because once we laid out exactly how many chances these people have been given to come into compliance, they were much more on board with they were the ones, in fact, who said, don't send them a letter from us, just refer it to PennDOT. And that was pretty surprising and good news for us that we were able to do that. These people have been given many, many, many chances before we go to license suspensions.
So we have, out of, you said 96 suspensions, there are only 20 responded year to date, is that right?
Yes, sir.
And unfortunately, these can't be done in batch. Each one has to be done individually on the case. You cannot just pick 100 cases and say suspend their licenses. It has to be done on an individual basis. So
76 who are suspended or just
suspended.
suspended?
We have no license.
I was going to say they're not driving, but that's not necessarily true. Okay.
If that were the case, we wouldn't have any driving under suspension charges.
Any other questions in regards to the license?
Yeah, you said you're having a difficult time determining who has a valid driver's license and who doesn't. Or these 96 definitely had driver's licenses
Yes, sir.
that have been suspended.
Yes, sir. Everyone had a valid license.
Well, 76 of them got suspended because the other ones being
sorry.
contacted. Yeah,
Yeah.
so 76 licenses have been suspended.
Any other questions?
Is there any confidence level that those 76 are just not, have no intention of coming back around, making a payment plan?
Well, the process is, we initiate it. It sits in a queue for a night because Kim has proxy to Denny's signature. So it sits in a queue. The next day, it gets sent through CPCMS and also to PennDOT. PennDOT generates the letter. The defendant has 30 days from the date of the letter from PennDOT to respond to us.
Oh, okay.
And if they fail to do that within 30 days, then their license are suspended, which incurs another $70 fee for a restoration fee on top of everything that they have to pay.
But essentially, we just, from our standpoint, we just kind of write them off the system at that point, or?
No, I mean, it's still an active payment plan, still an active case.
They just don't have driver's
They just don't have a driver's license. And we've actually found that.
But our efforts, well, I want to get at, sorry, our efforts are they caught in some other effort, or is that just kind of like, oh, they're suspended?
No, we can put notes or ticklers on the file, and then we can follow up, 30 days out to see if anybody's made a payment. And we can also go ahead, I asked Judge Brubaker, we suspend the person's license, can we also put a warrant out for him? And she said yes.
So there's still active options.
Mm-hmm.
Thanks.
So the 8 that paid in full and 12 payment plans, how much money are we talking about in terms of what they owe or owed?
I don't know, I would have to go back and look at the figures. Some of them are basically a speeding ticket, a couple $100s. But I'm having great success with cases that are 10, 15, 20 years old. And these people seem to be more compliant with paying for their debt to society.
You mentioned you mentioned some of these are out of state, right? So I'm just kind of curious as to what kind of dollars we're talking about in terms of the threat of the suspension and how much this has resulted in the collection of the debt.
I can run a report and I can email to you, and it will just show you who we suspended, who we also restored.
Yeah, I don't need names. I'm just interested in terms of
tokens.
what kind of what's the dollar amount since we in terms of what we've been able to recover through the use of the suspension of the driver's license as opposed to.
I can get that for you.
And then you said that those who have had did not respond in 76, they can get their license restored at some point. So now they have to pay another fee on top of
$70.
To PennDOT, not to us.
PennDOT.
PennDOT requires the $70 fee to restore their license. So even if they pay us in full, we still have to pay PennDOT. We're not collecting that. It's not over and above what we have to collect.
So they all know that
I think
in order to
that's-
get their license, restored, they need to first pay
Yeah,
up
because
or
PennDOT
enter
won't,
into a payment plan.
PennDOT won't restore the license until we, like, I hate the release, maybe is the word, we tell PennDOT it's okay to get the license back through the computer. I mean, we would mark in there, okay, this paid in full, and we basically withdraw the suspension. But then PennDOT doesn't hand the license back until they pay the restoration fee.
So someone owes 500 and we suspended the license, and they paid the 500, it still owes 70 to them.
Yes. We would tell PennDOT they're paid in full, we're done.
Which is another incentive for them to reconcile the
You
license.
would think.
The key to the program, PennDOT program, I believe the vendors, when vendors are providing notice,
Oh, yeah.
is it 30, 60 days?
Yes, they have 30 days to contact and for us to withdraw the suspension notice. I mean, obviously, anytime after that, if they come in and pay, we go in and say it's cleared up.
All these
But then-
notices go out by US. It's not. Okay. So it's never gonna work in every case, because you have a lot of people who have questionable addresses.
Well, yeah, but if you have a driver's license,
It's
your
gotta be
property
It's
is,
got
gotta
better-
be fairly
better
up to
chance.
date. Yeah, yeah. Not always, can't make that guarantee, but it's whatever address PennDOT has on file, maybe
Right.
not necessarily the address
Well,
we originally
The
have on file.
law requires if you change address, that you notify PennDOT
The law,
within 30 days.
the law also requires you to notify your probation officer and the court if you change your
Doesn't-
address, but that
doesn't
doesn't
mean
mean that
it's
it
not.
always
Yeah,
happens.
yeah.
So just so I'm clear
It's not
on
law.
it, the first time that we implemented the suspension of the driver's license in an effort to collect the debts was in May.
Yes, sir.
Okay. And that first test group, that was 7 defendants, and we had a good response rate, at least initially.
Yes.
Was that like just done on like that day, on May 5th, or was that over a period of time?
That was on that day.
That day, okay. And since that time, then, we have taken action against 96.
89. 89
Oh,
plus.
I'm sorry, okay, they just subtract that and 5 for the ones that, okay.
I think that the good news here is that you start. I think we've seen from other counties through some of the research that Mike did, that once this thing gets set up on a routine basis, for really high volume, that, the money just starts to come in. It is the most effective way of getting people's attention. So, keep it up.
That is very true. I mean, there's, even in some of these cases, we've sent final demand letters with no response. But as soon as they get that letter from PennDOT, they're on the phone with us,
Funny that.
ready to make a payment. All right, moving on to, I just put the ability to pays in there. How many we have done year to date? 252. And then the petitions and the bench warrants we've issued year to date, 1,092. And what I would like to, for you to look at is that total between those two is 1,344. If I were to allocate 15 minutes for those 1,344 cases, you're looking at 336 man hours. 336 man hours divided by 7.5 equals 44.8 days. Multiplied by 2 for this whole year, that's 4.5 months of work at my desk, not doing anything else but ATPs and bench warrants. My resources are tapped. We do everything in our office answering phones, administrative duties, filings, letters, run credit card payments. We are 3 people that have over 1,000 cases per individual assigned to us. We're pretty much tapped for our resources. And I would just like for you to look at that. 4.5 months is a long time just to push paperwork on 2 different issues.
One of the things too, just kind of off that topic, but sort of on that topic, with the ATPs, we do feel that that is successful, and it's also sort of required by law, to determine defendant's ability to pay. I had Mike, maybe 2 months ago or so, start checking random checks. Pick 5 or 6 of the ability to pay that you did 2 or 3 months ago. Are they paying? So we've ordered these people to pay $200-300 a month. Are they paying? And you said you've been checking into the random checks. They are. There's no way in the computer system to pull a report of we did an ability to pay. Are they paying? Because the computer doesn't care about the ability to pay. There's not a box we check when that's done in CPCMS. So I asked him to start just doing some random checks, and it based on the random checks so far, we are getting people to pay through that system.
I think the ability to pay is, if it were a cost center, that would be acceptable. It is required for this to be legitimate, and it was part of the arrangement with the court system. It is also very defensible in Michigan or different. On top of that, it helps increase the amount of money we get coming in and all of that. I think, though, the question about resources is, this is not unique, but it is distinct within the county in that the more effective you guys are at doing your job, and you know which of the things you do that produce the highest rate of return, you can then make to the commissioners an argument that additional resources could produce a positive rate of return rather than simply just a cost. So, for instance, ability to pay is a necessary thing. If that's bringing in an expert, but summary warrants bringing in Y, the driver's license suspensions are bringing in, B squared, then I think you can make an argument that adding a resource will result in a positive rate of return rather than just an additional cost.
We just want to go to the 3rd page then, which is the graph. Yeah. We had put this together just to show you, actually it's kind of fun looking because we're doing a good job. If you look at the blue line for 2015, I can just give you some history of the unit. The originators of the unit was Mike Hinkle and Missy Horner. And Mike was just upstairs today, and he left, he said, in December of 2014. So Missy was by herself probably till April or May of 2015. And then Lori Radel came on, and then you can look at their collection rate. And then you go to 2016, for whatever reason, there's a lot less than 2015. In this area right here, there was some personality and personnel conflicts between those two. Whatever happened, happened. I was interviewed the end of October, and then we get into 2017.
Michael, when did you start?
January 9th. So I came in the first part of 2017, and we had a steady increase. And then where we dipped in April was a transition month when new personnel were coming in and personnel were going out. And then we've had a steady increase since then. So I really like the use of that graph. It shows you really how much the figures have changed even in the last 6 months. That's it for the warrant collections unit. I can answer any questions if you have any. If not, then we'll turn it over to Mike Gottschalk.
try to debrief on mine. I gave a handout. I wanted to make sure the colors are on what you're looking at. The first graph shows how we're doing year-to-date 17, year-to-date being through the end of June. And so through the end of June 17, as compared to through the end of June 2016. And you can see Cumberland County is faring well, increasing their share of total court of common pleas collections by 10%. Also, Cumberland County boroughs and townships are doing well, increasing their collections from offenders through the court system by 29%. Restitution to insurance companies increases 98%. I suggest that is largely a factor of the very low collections for restitutions to insurance companies in 20,000 is a fairly low number, and then therefore it doesn't take much of an increase on that to show a large percent. And by the way, that could also be due to, and I suspect likely is, to the relatively small number of cases people started paying more.
It could have been one large payment.
It could have been one large payment.
One or two large payments
Yeah,
on a
so
small
I wouldn't
figure.
attribute too much meaning
Yeah.
to the increase, the 98% increase in restitution to insurance companies. Unfortunately, restitution to individuals, victims of crime is only at 5%. Michael's at, people have some context. That's up significantly as compared to year-to-date figures of May you mentioned. I think we'd all like to see a bigger increase in that. And hopefully we will with the new practices Michael was talking about. Total collections through June up in number terms $200,000 year-to-date 17 as compared to 16.
Can you, Michael, could you explain that's the first time I've seen this, I think, where we're referring to boroughs and townships. How does that factor into what the work of our collections unit?
Yeah, it's part of the, various statutes, depending on the type of crime, often traffic related. There's a fee that goes to the municipality. And so those are on there. So then as offenders pay, then according to the order of payment established through the AID or PC, then as payments come in, prescribed percentages of those payments get applied to pay the borough townships assessment.
The MDJ's collections, is that included in Cumberland County?
These do not reflect MDJs, the figures I have here.
But what this could reflect, is this criminal cases only, or
These are
does this
criminal-
include summary?
Criminal, well, everything flowing through the court of common pleas.
Okay, so this could actually include summary and M3 cases, which are actually cases transferred from the DJ to the common pleas,
Okay.
where they found the defendant guilty, they were ordered to pay amounts, the defendant did not pay at the DJ level within 30 days, can you see it? 30 days, I got that right? Okay. Within 30 days, they are required by law to transfer the case to common pleas. That's why you may see that township and borough on there. These were local MDJ, traffic, other kinds of offenses that simply were not paid within 30 days and they're required to be transferred to the common pleas for collection.
Okay, all right, thanks.
Then the second page just shows, I include the second page to provide context. Context is everything in evaluating how you're doing. And the second page shows the overall growth in the total receivable owed to court of common pleas in Cumberland County. And running the same report from AOPC at the end of 15, and then running that report again at the end of 16, which is supposed to be the net receivable. So these figures are after collections have been applied. And again, this is back in 16. It doesn't reflect where we are in 17 yet. But you can see that all costs, fees, and fines, exclusive of restitution, increased 8%. Restitution itself goes up variably year to year, depending upon the cases before the court and the decisions rendered.
One thing to point out with this though too, understand that from 15 to 16, the criminal caseload increased 15%. So we had 15% more defendants potentially ordered to pay money than we had the year before. And to put that in context, for 16 to 17, I believe we are already looking at a 15 to 20% increase in criminal caseload over and above the 15% it went up last year. So that's more money being ordered by the judges to be paid right off the bat with the same amount of resources as we had the previous year to try and collect on that.
I think Mike's point though is, and this is for all of us to understand on a global basis, as that denominator goes up, and we all know it does,
Yeah.
and the increase in caseloads is documented fact. We, even if we're doing better, may actually be getting in, overall, if what we're doing doesn't increase the numerator as fast as it increases the denominator, our percentage of collections is.
We could collect more and more and more money every year. We could get better and better and better. But if we're not matching our collections to the amount that is ordered by the bench, we are never going to catch up. And the reason, again, other than the addition of the collections unit, the resources on that collection side haven't increased in decades. And caseload has increased substantially in decades.
So we lost
But
ground.
you know what that doesn't explain, and again, we're looking at the past couple of years. What that doesn't explain is why we were collecting that much more in years past. And I'm gonna go back to 20.
Right, and we're bringing that, but we're bringing that dollar number up.
We
Right.
didn't have a collection check.
Right,
Still doesn't explain that. Still doesn't explain that.
right.
So what Melissa says is correct with facts. We're collecting more success in terms of amount than we did the prior year, but in the context of the total amount, we can still be losing ground, and it sounds like we may, just as we clearly did last year. So.
Am I wrong? Isn't that kind of the case of where we were for the last 10 years? Our amounts were reasonably stable, but when you measure them against the increasing caseload, the percentage was in decline.
Right. We were collecting the same amount of money, I believe, and I'd be interested to see that chart. Again.
Yeah, well,
It's been a while since I've
actually
seen it.
is the next page.
Oh.
Oh, it's true. Okay.
Oh, good.
Before we move on, can I, so that's a subject we'll get to.
Yeah, okay.
If I can finish. Of the amount on page 2, 1/3 or 20 million is on cases between 1 and 3 years old. 2/3 or 36 million are on cases 4 years plus or beyond 3 years. I just wanted to point that out. So 2/3 of the balance owed is on cases beyond 3 years old.
Okay.
Just to provide something. The amounts, and also additional context, the amounts with collection agencies currently, Michael mentioned some valuable new initiatives, one with collection agencies, the other with driver reps and suspensions. The balance we have with collection agencies represents 0.7% of the 57 million owed Cumberland County. So there's certainly room for improvement there. Why are we closer, 0.5% of the total balance? But it's a start, and we're showing success. In regard to the driver's license suspensions, York County collects $500,000. I mentioned that it's very important. $500,000 just through that one practice alone. So that does seem to be very fruitful when applied on a broader scale. York County does it on a much broader scale.
So I think if this is our MBA class, what you have is this huge potential market, almost money we have to focus on. In order to make a serious dent in it, we have to be doing the right things with the right amount of resources, both internally and using the third parties that we're using. That would include collections agencies. And I think right now we're tapping into a minuscule portion of what we could be doing. And then obviously with the PennDOT, we can use PennDOT as a third party to increase and ratchet up the license suspension stuff. But in order for us to penetrate that market more, we really have to begin operating at a higher level.
The third,
Do you know how many personnel that unit has in York?
four off the top of my head, I believe their probation officers are served in collections. They act as collection agents during the period that the offenders are on active supervision. In any case, I believe once they go off active, I think they come in then to the courts unit, which is equivalent to the WCU here. And they go. But I understand four, you should check.
So they're more proactive on the front end than we have been.
Seems so.
It also demonstrates that with more resources, again, you're gonna get a positive rate of return. It's not like you're adding additional people that don't bring in more money than the salaries and benefits cost.
So the third page is the graph that Melissa, in effect, referenced to Gary's question. The blue line is, the blue bars are essentially the collection levels, the amounts. And you can see from 2000, comparing the 2012 blue bar to the 2016, there was relatively minuscule improvement in collections, whereas clearly there was a marked increase in the orange bar, which is the assessment balances to be collected during the most recent 5 years. So in that sense, the effectiveness is definitely and clearly dropped over the 5-year period.
And Mike, I think we had previously seen charts prior to 2012 too.
Yes, yeah, we can go back on that. And we would see actually the blue bar, the gulf between the top of the orange bar and the blue bar actually shrinking in those earlier years. So the Court of Common Pleas had been much more successful about a decade prior out.
And we shouldn't be fooled that this is just mathematics. And if you look at the numbers we were doing, off the box office in 2005, 6, and 7 page, it wasn't just the fact that the denominator was increasing. There was a change in policy on the part of the courts that went from more assertive, aggressive collections to, how do we say, thinking a little less of a priority. While we diagnosed the discovery phase when we first started talking about this unit in 2013. So the courts appear to be back on board, but we still have a long, long way to make up in the context of growing the land, of growing the denominator. So it makes it more difficult. But it's also an enormous opportunity.
Assuming the offender profile hasn't changed, collection success is largely a factor of the assertiveness of the ask of the offender, party to pay, and then a variety of practices applied to try to collect. The final graph I have for you shows the 1-year collection success represents Cumberland County share only. The blue line, jagged, declining over the 12-year period, is year 1 collection success. And you can see we went from a high of 46, 47 to a low of 26 or 27, a drop of about 20%. Why the year 1, and why I keep referencing year 1 collection success is because you look at the data we get from the court system, and each successive year following year 1, collections drop by about 50% in any case. So by year 5, you're collecting about the court's collecting about 2%. So whatever you do in that year 1, you seem to not be able to recoup.
That's really important.
Yeah, so that's really important. I added a couple other lines to the graph this time. The red line is the mean percentage collected. So this is the average court success over the 12-year period. And we have about 5% to go to get back to our own, or Court of Common Pleas own average success over the decade, 12 years. The green line is also new. I added that. That's the average three high collection years for the Court of Common Pleas. The gulf between where we were at the end of 16 and the average 3 high years for the court represents a loss of $600,000 in collections. That's not our high year, but that's an end. So understanding collection success drops by half. Year 2, then the court could expect $300,000 additional in the second year. So it doesn't take long before you're up to $800,000 or $1 million. And this is only the county share, doesn't say anything about the success that the victims of crime would have with those additional practices and the sewer
Mike, can I ask
collection.
you a question? One of the issues, and I'm asking, I truly do not know the answer, I'm not trying to. One of the issues you're talking about, this is county share of first-year collections. Does the fact that we have 100% of payments going to restitution first have any impact on this? So if a defendant owes county money, but also owes restitution, every penny they pay for the first year or two, potentially, none of it is going to the county.
That's a very good point. I had brought that up with Denny.
Okay.
He asserted to me that he's always done it that way. I know he took office around about a dozen years ago. So he was the office holder who would have been aware of that decision and if not, have played a role in it. Certainly setting it up mechanically in the system. He asserted to me that it's always been that way.
What, 100% going to
Since
restitution?
he came in, that's what he told me. So,
20 years.
Yeah, he's been here way more than 12.
my dad goes back to
Oh, back to- okay.
2005. I know he was in office at that point.
So to your question, your point, if you look
It
back.
would still be the right comparison,
It's a
Yeah,
good comment.
but you're comparing apples to apples.
It
wasn't-
seems to be
Okay.
according to that.
Okay.
but it still doesn't explain the drop off from 2005 to all the way to 2013.
We heard about a change in the prioritization of the court. And that was just in terms of the aggressiveness of the collections, that was not in terms of the percentage. You're referring to the aggressiveness.
Yeah.
Is that a hesitation to use probation? Or what do you mean by less aggressive?
This is, I think, we've made a number of presentations, particularly back when we first were trying to get this thing set up and went into the discovery phase. It's a complicated problem with a relatively simple answer, and that is that for whatever reason, the will to go after the money dissipated. Either part of it, I think you can blend in, you can attribute it to the economic recession, but even after the recovery, there was not a similar recovery of collections even after the recession was over.
This is well before the recession really took root here.
Yeah, well, 2007 is when the proverbial stuff hit the fan, but the fact is that there's no correlation between collections and the state of the economy.
Right.
The fact of the matter is that there was the view held by the courts that, and this is how we got to what was the number that was there that you had to pay every month? Even
$60.
$60. Okay, because no one took it seriously. Anybody, whether they had $1 million or they were on welfare, it was $60.
Is that type of direction, I know you were not here in your current capacity at that point. Is that direction set by the president judge? Is it set by a consensus? Is it just happened by
I
default
think it was
somehow?
generally kind of a default thing. We did not have any kind of ability to pay process in place, so the general ask was, how much can you afford to pay? And they took the defendant's word
Standard
for it.
response would be not much.
Right, and somehow everything kind of centered, Darby wasn't here for that either, the $60 was just something I think everybody kind of centered on, and that was kind of the default, well, I don't know what can you afford $60? And that was kind of just the question everybody got asked. With the and the judges didn't have any other information to base it on. In standing in court when you've got 100 defendants waiting in line, you don't have time to go through an entire, how much you make, right, it just.
Default in collections is not a secret.
Right,
So-
yeah, it wasn't considered a priority. It just was not a priority. As long as they were paying their $60 a month, we
Not
didn't.
only was it not considered a priority, but this is prior to Darby's arrival. It was viewed, trying to collect was viewed as detriment or a takeaway from the rehabilitative goal of probation. And the two, as long as you pass them in contradictory terms,
Right.
okay? It's also was part of the notion that has helped lead to the filling up of our jails. Okay, that, you basically, you don't get into sophisticated collections technique, you don't take it seriously, then, you know, you have this sort of minimalist view, and in the end you throw up your hands in the air and you throw people in jail. So you have the worst of both worlds. You have the jail filling up.
So that line's going up.
Right. You just
Collections line's going down.
and you're not collecting money because you have such a minimalist view of things that you're saying, well, if I try to get money from them, then we won't be able to accomplish anything else. And I think my understanding is, you know, Darby's trying to move things in the other direction.
Yeah.
But I will tell you, and I don't mind saying this, that during our negotiations with the Teamsters, I sat and listened to more BS from the probation officers, the adult probation, about what a great job that they're doing, and when confronted, in order to gain on contract negotiations.
Right.
And when countered with the actual numbers, which I happen to have and provided for their amusement, they had absolutely nothing to say.
So we call this the Hoffer curve.
Hey, he's not very good at himself.
Well,
But I think that attitude is changing. I was actually pleasantly surprised. I sat in court on Monday for a little while, first day criminal trials. I was sitting in miscellaneous court, crossing stuff off my list. And it was very nice here. It's been kind of a hard road with some of the judges changing the mindset. I mean, they were on board, but you know, when you're in the rut of court, you go back to what your muscle memory or your brain was telling you. I sat and listened to Judge Guido not ask people how much can you afford to pay. There were several defendants who owed restitution and were ordered to pay a default $250 a month payment. If you do, and he would mention that if you do not feel that you can afford that, you can go to the request and ability to pay hearing, but until that time you were ordered to pay the $250 a month. I heard him order a guy who only had $241 in restitution, ordered him to pay $250 a month. Costly fines on top of that, but was ordering that on a regular basis, and I think that that's been a huge mindset change for the judges. And not that they didn't want to collect money, I really think they had a feeling that we couldn't, that it was getting blood from a stone,
Right.
and that the resources were not there to determine that ability to pay. Having that in place, they then got the paperwork right in front of them. How much they make, what their expenses are, on all that information is in front of them. It's a lot harder for a defendant to argue that they can't pay it when we've got their financial information, or if they refuse to provide their financial information.
My point in raising the questions was specifically because what we don't want is as the makeup of the court changes, that we fall back. Now, you've institutionalized a number of practices here and information availability that you've heard of that. But I do think that's something we should be able to
Be very cognizant
I
of,
think,
yeah.
and I think, again, with due appreciation for what Darby is trying to accomplish in adult probation, much of the onus for collection falls on adult probation, because there are people that have them in that first year.
Right.
And I will tell you that in spite of everything that Darby is trying to do, Darby went to the Sam Miller School of Evidence-Based Best Practices. He's trying to turn things around, and I think to a certain extent, it's beginning to see that. But you do have institutional profound resistance to this amongst the rank and file adult probation officers.
Well, it's department institutionalized by the
Yeah,
collective bargaining unit.
and without trashing the fact is they're protected under a union contract. And it's not to say that everybody in adult probation is of this mindset. There's been some significant changes, not only in terms of collections, but also in terms of some of the more creative redirection programs to keep people out of jail. But the fact of the matter is, if you sit there and talk to a whole bunch of them, you realize that they're very progressive minded for the state of the science about 1978. These are the folks that unfortunately run the collective bargaining unit for them, and unfortunately probably give a less than stellar name to the whole department, and certainly to what others is trying to
Well, it
accomplish.
sounds to me as if you are insinuating that we can only expect a certain amount of progress as long as those particular folks are in place.
Or their attitude changes.
I would just like to remind the commissioners that the probation office did collect in the first 6 months $2.5 million, up 5% from last year. And a lot of this comes down to manpower. There's complacency, but there's complacency on all parts, the courts, the probation office, the county. No one wanted to. We have the 3 same compliance officers positions that we've had over the past 20 years. The staff complement didn't raise. So this is a joint complacency effort that got us to this point in 2013. I don't think you can blame one particular group. We all had a part of it. We're trying to come out of it.
That's fine. Our concern is what's forward-looking, and we've tried to institute a number of changes, and if we're going to encounter resistance in one part of those, we need to be conscious of that and be engaged in combating that.
There's just also along those lines, and I appreciate the improvement already in probation, but you know, if it's made part of their jobs and a priority as part of their jobs, whether they're union or non-union, you know, I think that's important. One of the things that I was interested in is when we created this unit, you know, does that mean that probation is no longer, you know, responsible, you know, for the collection or efforts to collect the debt? And you stated that no, that's not the case. We're all in this together, so that's good. That's what I want to hear. And you know, as far as you know, probation officers, you know, this should be part of their duties and responsibilities, and it should be made, you know, maybe a priority as far as their duties and responsibilities. But so, I guess my question, and I've been asking this question since I got here, but you know, to see this drop off from 2005 to where we were through last year, is that when we started to say that you only have to pay $60 regardless of what your income is? Is that when it started? Or?
I honestly don't know the answer to that. I wasn't in the position I am in now until 2008, and it's only been in the last few years, I think since Darby came on board, that the much more collaborative efforts between probation and court admin, with the addition of the WCU, has really started. No disparagement to John Roller, but he and I didn't have much contact. I probably talked to Darby, once a week at least? Sometimes more than once.
I can tell you during that point, we did have a collections court. We did have one of the judges as the collections judge.
What, in 2005?
Around that time when we stopped using the collections court.
Well,
so that had something that we now
established that with Judge Becker.
So that's something.
But when I got here in 2013, we started that discovery phase shortly after I arrived. That $60 a month in place for as long as most people around the table. And we had everybody around the table as long as they could remember.
I don't know if anybody could ever figure out when and how or where that started, but it somehow became institutionalized.
And I think you have to understand, as Mike said earlier, when it's ability to pay, the amount of time it takes for that, and it was at that time, if I go back to the manpower issue, there wasn't enough time at the day to figure out and do what Mike and his group are doing now to figure out the defendant's ability to pay. So it came down to that: what can you pay?
Well,
was that the right way? Probably not. But that's
Okay.
what we're left with.
All right, so there wasn't an awful lot of effort put into the question of the ability to pay.
There was no effort put into it. I think
Even though, you know, Mike's saying that's a requirement of law, or we got a requirement from the state to do that.
You are required to determine whether a defendant has, I forget the exact wording, has a true ability to pay. You can't just throw them in jail if they do not have a true ability to pay. Well, if you don't know what their ability to pay is, you're going to be less inclined to throw them in jail, because if you throw them in jail and it turns out they don't have any money, you just violated that requirement that they have the ability to pay.
So we did not do a good job
No, there were a few
of
big,
actually determining ability.
right, there were a few
And
big money.
we didn't want to set up a debtor's case.
Right. There were a few big money cases, I know even early on, that occasionally, Michelle's group, I think that was probably before your time as well, heading up in there, we would see where the victim services or the DA's office would push for an ability to pay big money, $100,000 owed, and the person was paying $20 a month. They would push the court to do some sort of ability to pay, and there would be a full-blown hearing on income and expense. I mean, hearings that would last hours to determine someone's ability to pay, because it was all on the record and it was back and forth. Those were few and far between. They were rare, and they were generally on big money cases, and that was about it. But we've now made it part of the process. You're either going to pay $250 or you're going to get the ability to pay.
But things like this don't happen by accident. They don't happen because of fate, destiny, or change in the facts. These are decisions, a series of decisions over time. That was made. The downgraded decision. The attempt now in the last 2 years to try to reverse that. We've been partially successful. We think we now have found ways that predict success better success, more success going forward. They will require judiciously more resources that are placed in doing things that will actually generate more revenue relative to their costs. And I think we have to take a look at this from a county perspective, not just from the WCU, as to the total manpower devoted to this task throughout the county and all its departments, and figure out where the best use of those resources would be.
I would be interested in how York County's collected $500,000. You know, exactly what it is they're doing. Is that their probation officers?
No,
That-
it's,
Donna Shelter.
I think we may have presented this before, Alan Michael.
I mean, York County's a lot bigger than New York.
York County at the time is a great story. We had Judge Kennedy from York, and then we speak to our judges. At some point, there was a staff overall reduction in workforce. And basically, the adult probation department was looking to get out of the collections business and use that as a way to fulfill their quota in terms of staff reduction. And then the very savvy person over at the clerk of courts said, that's okay, we'll take it on. And that's what happened. So the function, the collections function was transferred from adult probation to the clerk of courts as a result of an overall downsizing within the county. But the difference is that the clerk of courts over there, led by Mr. Rochelle, really saw that there was basically the implementation of your standard effective accounts receivable management techniques. You could bring in a ton of money, and that's what he's done.
Oh, okay. That raises a good question. Thank you.
We have to wrap up. Are there any other comments from anybody?
I'll just let you know when we get our $60,000 month.
Okay.
I was on vacation, I got a text.
Yeah. Any other business to come in front of the board?
Thanks a lot.
Thank you.